Good evening, everyone. John Eligall with the New York Times, back for another edition of Race Night, our weekly conversations about race. And as always, I'm joined by my colleague Rachel Swarns. Rachel, good evening. How are you doing?
Hey, John. We have quite a busy news week, and it's
Yeah,
only Wednesday.
yeah. It's been a pretty busy news month, news week. News whatever you want to call it. It's like things keep happening one after the other. So we have we're going to talk about some of that today tonight. And specifically, we're going to talk about immigration again. I know we spoke about it last week, but hey, it's still in the news. And this time, because yesterday the Supreme Court upheld President Trump's travel ban, and essentially what this does is it bans people from several majority Muslim countries from immigrating to the United States. And the Supreme Court, after it had been suspended by several lower courts, but the Supreme Court, in a 5-4 decision, upheld the travel ban. And we have two very great guests to talk about that tonight, to talk about the implications of it, what it means. First, we're joined by Andrew R. Arthur. Andrew is the resident fellow in law and policy at the Center for Immigration Studies. Andrew, how are you doing?
Doing great, and thank you for having me, John.
Thank you for joining us. And we're also joined by Sirine Shebaya. Sirine is a senior staff attorney with Muslim Advocates. Sirine, how are you doing?
Great. Thank you for having me.
Thank you for joining us as well. So I want to remind our viewers, if you have questions or comments for either of our guests, please do put them in the comment section, and we will ask some of those. But I just want to start off with you, Sirine. Obviously the Supreme Court, 5-4 decision, I said, upheld this ruling on the travel ban. And I'll just read a quote from Justice Roberts, Justice John Roberts, the Chief Justice who wrote the opinion. He was basically saying that, hey, it's within executive authority to control immigration, to control immigration policy. And this is part of what he writes. He wrote, the issue before us is not whether to denounce the statements, meaning statements that Trump made about Muslims. It is instead the significance of those statements in reviewing a presidential directive neutral on its face, addressing a matter within the core of executive responsibility. We must consider not only the statements of a particular president, but also the authority of the presidency itself. Sirine, is Justice Roberts is saying it's within the president's authority. I mean, I'm assuming you disagree with that?
Yes, we do indeed disagree with that. I mean, one of the things that's been really remarkable about this case is that it's really quite rare to have a case where the evidence of kind of targeting and animosity towards a particular group is so clear and kind of an unbroken record of years and years of statements that are directed towards Muslims that express anti-Muslim sentiments. I mean, as Justice Sotomayor noted in her dissent, this is a policy that started as a call for a total and complete shutdown on Muslims entering the United States. So I would just say that, for Muslim communities yesterday, for all the people who are impacted by this ban, it was really very sad to kind of see the court choose to step aside and not to address what really has always been at the core of this case, which is that when a policymaker like the president makes so clear that anti-Muslim animus is what's animating a decision, that policy is allowed to stand. And I will draw one contrast with another case that the court decided this term, which is the Masterpiece Cake Shop case, where the court essentially went out of its way to find evidence of religious bias because it was a Christian baker who did LGBT couple, whereas in this case, there are 150 million Muslims who are impacted by this decision, and the evidence of animus is much, much stronger, but the court decided not to sort of pay heed to that or not to take it as seriously as it did a throwaway comment from a commissioner in a situation where that really wasn't the driving force behind the decision.
I want to ask you, oh, sorry, go ahead, Rachel.
No, I was going to say, Andrew, I'm just curious what your take on this is. Obviously, the president says that it's, what he wants to do is to ensure that Americans are safe, and and obviously supporters of this travel ban think it's well within the president's authority to make such a decision. What's your take on this?
Well, there are a couple of different things here. The first and most important one is the fact that the Ninth Circuit decision below, which is Trump versus Hawaii or Hawaii versus Trump, was dependent upon the fact that the president lacked the statutory authority to do what he did. That was the entire gravamen of the Ninth Circuit's case. They didn't decide it on Establishment Clause issues. They didn't decide it on whether there was racial animus. They simply determined that the president lacked the authority under Section 212F of the Immigration and Nationality Act to take the action that he did. And that, in fact, the action that he took was banned by Section 202A1A of the Immigration and Nationality Act, which bars discrimination against individuals on the basis of nationality in the issuance of visas. Curiously, not one of the justices of the Supreme Court actually attempted to defend the decision of the Ninth Circuit itself. Rather, the Justice Roberts in his decision did an excellent job of explaining how the president has great authority under Section 212F of the INA to do this, how Section 202A1A only applies to visa issuance, whereas this applies to inadmissibility to the United States. So these were, issues. That really was the crux of the case in the Ninth Circuit, completely ignored by every one of the justices in the case. The dissent decided to focus on the Establishment Clause issue, which the Ninth Circuit didn't reach. The majority did a very good job of addressing those issues, but it's very important to put the statements that then candidate Trump made into context. In October of 2015, I believe it was, then FBI Director James Comey talked about the difficulty of vetting individuals who had come from certain countries where we just don't have information. This is well before the presidential proclamation was ever issued. In fact, well before Donald Trump was ever the Republican nominee for president. Thereafter, in October of 2015, the Director of National Intelligence, James Clapper, President Obama's Director of National Intelligence, talked about the danger that terrorist elements could attempt to insinuate themselves into the flow of individuals coming from Syria. If you remember back in 2015 when there were a lot of people going into Europe, a lot of refugees or economic migrants that were going into Europe, that this was a very serious issue, and we'd seen attacks in various places. In November of 2015, we then saw the attacks in Paris. That was the Bataclan attack in which 130 people were killed.
Hey, Andrew, I'm sorry. Can I just interrupt for 1 second? I just want to the point you talked about, what Clapper and Comey said about terrorism. What do you say to the point that the countries that are under this ban, like most of the terrorist acts committed in the United States or in U.S. territories, I forgot what the exact number was, but very few, if almost none of them, I think, were from these countries of origin. I mean, what do you say to that argument?
Well, it misses the point, John, because the issue is the statements that Trump made that Sirine talked about and that were talked about by Justice Sotomayor. The Bataclan attacks took place in November of 2015. It was 3 weeks later that the San Bernardino attacks took place. That took place on December the 2nd, 2015. The statements that Sirine has referenced were made 5 days later by then candidate Trump. And Justice Sotomayor does not put those statements into context. If you go back in time to the concerns that people expressed at that time, I was working for the National Security Subcommittee at House Oversight and Government Reform. We had 2 hearings within 1 week on exactly the issue of the possibility of terrorists entering the United States from Europe who had come in through the refugee stream. So the statements that were made really need to be read in that context. Thereafter, Trump also made some statements to Anderson Cooper at CNN in March, and at that time he again referenced the Paris and the San Bernardino attacks. So taking those statements out of the context of the time in which they were made, is very difficult and can lead to a conclusion that is not necessarily true. This proclamation is the result of a multi-agency effort between 2 departments and multiple intelligence agencies to establish a baseline for vetting of individuals coming to the United States. John, with respect to people who commit terrorist attacks in the United States or here, that's police work. With respect to keeping people out of the United States who may commit terrorist attacks, that's actually what immigration policy is supposed to be about, and that is national security.
Well, I guess part of that is the question of are you targeting the right countries? But Sirine, I'll let you jump in here. I mean, what do you say to that? I mean, that the statements that Trump made, it's not taken into the proper context when you look at what's been going on in the world.
Well, there's a lot packed into my colleagues' comments here. I just want to kind of highlight three points, actually. The first point is that as recently as last year, DHS itself undertook kind of a review about whether an appropriate national security measure is to ban entire nationals from entire countries, and itself concluded that that was not the case. And dozens of national security experts weighed in. A bipartisan group of national security experts weighed in to say that you don't actually address terrorist threats by banning people from entire countries, and also to kind of confirm the point that those countries have not, presented any kind of threat that is different from what comes from somewhere else. I actually think that saying that situating the comments in the context of San Bernardino and Paris somehow makes them better is, almost offensive, because when the Charleston attacks happened, nobody stood up and said, well, all Christians are terrible, or made some comments about Christians that then are justified because, some person did something that was really bad and happened to belong to a certain faith or faith tradition. I also think that when it comes to Trump's statements, it's not about one statement. I mean, this is something that the lower courts really had developed very, very thoroughly, of kind of talking about and documenting time after time, from the moment where he talked about a total and complete shutdown on immigration, to the moment when he was retweeting, unverified videos that turned out to be false, that had anti-Muslim content in them, to all of the statements that he made in between, explicitly tying the ban to sort of a picture that paints with a broad brushstroke an entire community as a threat, and kind of vilifies that community, and enacts things which in fact end up resulting in a picture where people can't join their family members here, where persons from those countries now feel that they don't fully belong in the United States the way that someone else does, simply on account of their religion and their national origin. And just to kind of move into the third point, yes, the Ninth Circuit ruled on statutory grounds. The Fourth Circuit ruled on constitutional grounds. And when the Supreme Court granted cert in the Ninth Circuit case, it chose to include the constitutional question, and in fact, it addressed the constitutional question in its decision. So I think it's fair game to talk about both, because the court did address both, even though, Andrew is completely correct that the Ninth Circuit only talked about the statutory arguments. If I can make one more point about the statute, 212F is a provision that has been used very sparingly by presidents up to now, because when you use it broadly in the way that this president is using it, you essentially create like a rewrite of the immigration laws. And this is part of what makes Roberts' analysis of this statutory provision very troubling. Because Roberts kind of said that this provision, or the majority opinion, the court decided that this provision grants broad discretion to ban essentially what amounts to about 120 or 150 million people, depending on how you count, from coming to the United States, and that doesn't sort of supplant a very detailed statutory system with eligibility criteria and with very specific sort of admissibility criteria. And even more troubling is the conclusion that the non-discrimination provision only is tied to the sort of ministerial act of issuing the visa, because the admissibility criteria themselves are what makes this real. I mean, the government itself has admitted that the way that they're enforcing this is to not issue visas to people from those countries, which goes flatly against the text of the statute, which says you cannot do national origin discrimination in the issuance of immigrant visas. And this is specific to immigrant visas. And in order to understand that provision, it's critical to place it in the context of the Civil Rights Act and all of the kind of changes that were happening at that time, and the Congress kind of standing and saying, yes, we used to discriminate against people from China. We used to discriminate against people from Japan. We are saying we are not doing this anymore. We are not saying that if you are from this country or that country, you're more welcome. And the result, I think, of today's decision is that it's going to make it much, much easier to discriminate against people of color, against minorities, against people from religions that happen to be disfavored at this time by the administration, in allowing them to come to the United States. And it's really just a very sad day, I think, that the Supreme Court has chosen to take that path.
Andrew, I'm wondering if what you make of that discussion and those concerns, which I'm sure you've heard, that this will have a harmful impact on people. I'm wondering if we could kind of leave the court for a second and go out into the nation, and also too, if you could talk on the flip side in terms of the efficiency of this. Do you think it will make Americans safer? But first,
Well,
what about the impact on communities, which a lot of people are raising?
Let me just respond to what Soraya said for just a moment. Certainly didn't mean to give offense. No, I'm sorry, Sirine. Certainly didn't mean to give offense. But of course, I also remember that after the Charleston shooting, which was a horrible tragedy, Governor Haley actually took very strong action. There actually was a groundswell of support in the country against many of the beliefs that that individual had. If any positive thing could come from such a horrible tragedy, it plainly did in that instance. Context
But it
matters,
wasn't all Christians, right?
It wasn't all Christians, but it was definitely directed towards individuals who had some pretty twisted beliefs, and strong action was taken against them. With respect to this, we need to get back to the basics of what this is about. It's really about vetting. It's about our ability to vet individuals before they come to the United States for national security concerns. The countries in question are problematic because they don't meet the baseline, be it with respect to identification management, whether it be our ability to gain national security and criminal information from these countries, or whether these countries pose a public safety risk. We're talking about Syria, which is a country that has been in the midst of a horrendous conflict for years. Somalia, that spent decades without an actual government. Libya, in which we saw significant disorder over the last few years. Our ability to verify the identity of any individual who comes and applies for a visa is very limited in those contexts. Also, our ability to obtain from those countries information related to national security risks they may pose, criminal risks they may pose, if we can't actually get that information from the country, then we're not really going to know a whole lot about the person, even if we can identify them. Finally, with respect to the last factor, the public safety risks that they pose, we need to consider whether there are terrorist groups that are operating in that country. And we saw this most significantly on September 11th. Afghanistan was basically a terrorist haven for Al-Qaeda, and they were able to operate there. Afghanistan at that time, posed the sort of risk that that was under analysis by the Department of Homeland Security, the Department of State, and the intelligence agencies. Iran, which is on this list, is a country that has interests that are inimical to the United States. And so our ability to rely upon information that we receive from the Islamic Republic of Iran is very limited. And again, this is not a total ban. There are exceptions to this, significant exceptions. There are waivers that are available. And as the court itself noted, some countries have been removed. Chad was removed from the list because they actually came into compliance. So the order has two purposes. One, our ability to vet, and two, our ability to get other countries to come into compliance with the baseline.
And Andrew, just to Rachel's question, though, do you think this will make America safer?
Do I think it will make America safer? I think it will make our vetting, our ability to vet individuals coming to the United States stronger, and that itself will make it safer. And as these countries begin to develop the structures that they need in order to comply with the baseline, you will see these fall away, as you did with Chad. We might see additional countries added to the list as they themselves fall into conflict or have governments that are inimical to the United States.
And Sirine, Andrew mentioned, exceptions to this, and I understand. I believe you all have been doing some work on these exceptions and how they're being granted. What do you? I mean, is that a fair point, a valid point that hey, this is not a full scale everyone absolute thing. There are exceptions, and it's not permanent necessarily. So what do you say to that?
So I will respond to that in 1 second, but I just want to point out that actually Somalia passed the baseline test, as did Iran, on a number of factors, and yet they still were in the order. So I think that even if you are looking at this from the perspective of like, oh, this was a review and a test, the test was actually designed to determine what instances a person may obtain a visa waiver, and so not have to actually go through the entire visa application process, which is a very different question from whether you're supposed to ban someone entirely. As it stands, our immigration laws place the burden on the person who wants to come here to apply for a visa, to prove their identity, to prove, that they don't pose a threat. All of these things, the burden is on the individual who's applying for a visa to do that. And the only thing that the visa waiver program does is that it takes that away from the individual and it puts it on the government. And so therefore, a review process that looks at the information sharing between governments is uniquely ill-suited to determining whether a country should be banned or not. And again, as I said, I mean, even on its face, some of the countries that were included in the ban had actually passed the baseline test, and some of the countries that failed the baseline test were not included in the ban. But even if you leave all that to one side, the ban has some provisions for exceptions. They're called case-by-case waivers that could be granted. And if you read just the face of the order itself, it seems to be sort of an orderly process. There are 3 criteria that you have to meet. You have to show that you would suffer undue hardship if you're not allowed entry. You have to show that your entry wouldn't be detrimental to the national security or public safety interests of the United States, and also that your entry would be in the national interest of the United States. So there are criteria that are delineated. The text of the ban suggests that you just demonstrate your suitability for these criteria, and it kind of lists like a pretty broad range of examples, like from deep ties to the United States, or that you were here before, or that you have, medical needs. And so if you just look at that, you think, oh, okay, well, you can apply for a case-by-case waiver. Unfortunately, the reality on the ground has really kind of driven home the point that this is a total and complete shutdown on people from those countries coming to the United States. Waivers are just not being granted. The government has not even provided a process by which people can apply for those waivers. Attorneys who want to help people get waivers have had to sort of invent, essentially, we have to figure out, okay, like what is your situation? We put together sort of documents that people might be able to submit in support of their waiver applications, but the government continues to say that there's no application process. The government continues to sort of refuse to provide meaningful information about or guidance about, like, who's adjudicating these things, who has responsibility for them. It asserted that several hundred waivers were cleared, which would be sort of like, I think, in the range of 2% of applicants have been cleared for waivers. But what became clear as we kind of were talking to the community members and immigration attorneys is that being cleared for a waiver doesn't actually mean that you get a visa to come to the United States. So really, the cases in which someone got a waiver, got a visa, and came to the United States, you can count them on one finger, and they include super high-profile cases, like a 10-year-old girl with cerebral palsy whose situation was so high-profile that Justice Ginsburg actually asked about her in oral argument. And only after that, after she hadn't been granted a waiver, was she granted a waiver and a visa and able to come here. So I think really, as Justice Breyer rightly noted in his dissent, by all accounts, the waiver process has been a complete sham and window dressing, and just a way for the administration to sort of pretend that this is not a real ban, but that in actuality, it really is a ban.
And we have we're got to wrap up soon here, but I do want to read some comments. I think we're contractually obligated to read some of these comments that we've gotten here. So we have from Lauren Elise. Sorry if I'm saying that wrong. Lauren says, it's a disgrace, proof that the Supreme Court has lost its way. Our forefathers are turning in their graves. Tom Smith, this decision will live in infamy. The equivalent of the decision to allow internment of Japanese Americans during the Second World War, a disgrace. And as a side note, that Korematsu decision that allowed Japanese internment, it was actually overturned as part of this the court's rulings today. So just as a side note. But I guess, we got, like I said, we got to wrap up soon. But the other big news of the day today is Justice Anthony Kennedy, who has been the very crucial swing vote for many years now. He has announced that he will be retiring, and I just like from both of you all, from Andrew and Sirine, I'd love to kind of get each of your takes on how you feel how you feel about the Supreme Court now and where it's headed. Are you excited? Are you lamenting it? Are you loathing it? Like how do you feel? Andrew, can you first tell me what do you think now with Kennedy retiring, where this court is headed?
Well, I've seen a lot of concerns in the past, and I know that we're very short on time. I want to give Sirine the opportunity. We heard a lot of concerns in the past about how Neil Gorsuch would be this, awful justice. And then Neil Gorsuch provides the fifth vote in DiMaio versus Sessions, which was an immigration case involving crimes of violence that actually went against the government. You never really know. As long as you put good people to the bench, let them rule the way that they will. If you're worried about their political bent, you shouldn't be talking about a court at all. You're actually talking about a mini legislature.
Gotcha. And Sirine, your thoughts?
Well, I think one of the really critical things about the court is that it has been sort of like a last bastion, or a place where you can go to get your civil rights enforced, where if the majority is discriminating against the minority, the courts have historically been the place where you can go to get relief. And unfortunately, over the past, a few years, this has become less and less the case. It's become very difficult for people who are suffering harms to go into court. It's become very difficult for them once they get to court to have their rights vindicated. And, I think we have genuine concerns. Like, is the court going to continue playing the role that it should, which is a check on, executive excess, a check on, legislative mistakes, a check on abuses by government of people's civil rights? That's why the court, fundamentally, why the court exists. And I think we certainly have concerns about whether that's going to continue to be the case. And we do feel like there has been a progressive closing of the courthouse door in ways that are really detrimental to the civil rights of people of color, of immigrant communities, of people who are fundamentally the most vulnerable and the most, subject to abuse. And so they are the ones who need the protection of the courts the most. But unfortunately, a lot of decisions, including, for example, this kind of contrast between Masterpiece Cake Shop and Muslim ban, have shown that, more often the court is actually standing on the side of the majority and against the people who, who need this protection the most. So, I can't say, I actually agree that when there are good people on the bench, that's a good thing and that's what you should want. But I also think that the courts have a really important role to play in keeping the doors open for people vindicating their rights. And so we'll have to see how that plays out.
Okay, great. Well, thank you both for that very lively but civil discussion. I don't think you'll see that on CNN or Fox News tonight. So, thanks both for joining us. I want to thank all of our viewers for watching. And again, we're here every week, every Wednesday night. And we want to continue the conversation with you about race. So go to nytimes.com/race-related and sign up for our weekly race-related newsletter. You get all sorts of interesting, exclusive content from New York Times journalists. And the best part of it is that we want to hear back from you. We do call outs. We ask you what things you want to talk about in this very important and difficult conversation that we have to have about race. So once again, Andrew, Sirine, thank you both for joining us. Rachel, great speaking with you as always, and we will see you all next week. Good night.
Thank you.
Good night.